Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 102, we're going to dive into a subject that it's hard to really create a consistent narrative on because it really dives into issues that can vary by state. But we're going to take a brief look at kind of the top of the bell curve as it relates to trust interests in divorce and how those might be treated. And in particular, the context under which we're going to look at this is looking at the more traditional third-party trust that's created by a grantor outside of the marriage versus a spousal trust like a SLAT that's created by one spouse for the benefit of another. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, one broad theme here is that a lot of people never really dive into the general state law theme that interests in trusts are indeed property interests under the laws of most states. That's ignored because in a lot of cases, a trust will contain a spendthrift clause which restricts the transfer or alienation of any beneficial interest in a trust. So because of that, trusts usually aren't divided up in a divorce, but that doesn't mean they're not completely ignored. And it also means that they may be taken into account for other purposes in determining how much a party might have to contribute from their own assets to a divorce property settlement or alimony and separate maintenance and so on and so forth. And in particular, while I'm not going to dive into the subject in detail, it's important to note that spendthrift clauses are not hard and fast rules that have to be followed. There are public policy exceptions to a spendthrift clause, especially around divorce. And specifically child support in a lot of states will ignore a spendthrift clause in determining the amount of assets that are available to satisfy child support. So we're going to kind of consider the nature of these trust interests in divorce, looking at a few common themes, but as I mentioned, we're looking at the common themes and not necessarily how every single state treats trusts. We're really looking to the top of the bell curve here because states are going to vary. Now, as a starting point, I want to dive into revocable interests. It might be the case that a parent or somebody has created a revocable trust that includes a child as a beneficiary, and now the child as an adult is getting divorced. So how is that treated? Well, in many states, if a trust interest is created by a third party and it's revocable, then the divorce court is not going to consider that. It's not going to be treated as a property interest. However, it's important to note that a form of irrevocable trust is coming into vogue, the incomplete gift trust, which is usually used for asset protection purposes or for state income tax planning purposes. So it's important to note there that state law really controls that revocable versus irrevocable piece. So with an incomplete gift trust, it would usually be an irrevocable trust, even though the gift itself is revocable or incomplete for federal gift tax purposes. So we're not talking about an incomplete gift trust here. And in particular, once a trust becomes irrevocable, or once a completed transfer is made to a spouse as a beneficiary, maybe by a distribution from a revocable trust or from an incomplete gift trust, then that transfer is complete and must be analyzed in that context at the time. And in particular, what I want to note is a transfer to a spouse might be a gift, which is the spouse's separate property, and would be taken into account in that light depending on the circumstances. But if that property is commingled, it may become marital property as well. Now, when it comes to irrevocable interests, we're concerned about these if they're from a trust that's created by a third party outside the marriage, really for two purposes. One, determining whether the interest in a trust is a property interest at all, and if so, is it separate property or marital property for purposes of the divorce court's creation of a property settlement. And two, would the trust interest be an economic circumstance that the court takes into account in determining alimony or separate maintenance, and, as I mentioned earlier, child support, which we're not going to really dive into here. We're really just concerned with the relationship between the spouses. But there's a lot of factors that come into play. And the top of the bell curve here is going to be that trust interests usually are not classified as property at all. They won't be separate property or marital property or even property as long as there's no economic certainty to the trust distributions. Now, what I mean by that is that if you have a trustee, preferably a trustee who's not a beneficiary, i.e. who is uninterested, and that trustee has discretion to distribute principal and income. In that case, since there's no guarantee that the trustee would distribute any principal or income, that can prevent that trust interest from rising to the level of being property. Now, what's unclear based on the state is whether the presence of an ascertainable standard would throw a wrench in that and cause the trust interest to rise to the level of property. I can only speak to Colorado and say that in Colorado, the ascertainable standard doesn't affect that analysis. So even if it's a discretionary trust with respect to HEMS, it still would not be a property interest. Similarly, depending on the state, an interested trustee, i.e. a beneficiary as trustee, may affect that analysis as well. Now, another thing as we move up the chain is if you have any sort of guaranteed benefit coming out of the trust, such as mandatory income, or maybe annuity or unitrust distributions, or lifetime withdrawal rights, or even use rights, all of those could be an economic interest that rises to the level of property in the divorce court and then would be classified as separate versus marital depending on the state. And then one weird outlier that I cite for Colorado, I don't know if this is the case in other states, is the court might also look to whether the beneficiary has a vested remainder, and if so, that might be treated as property as well. That was under a well-analyzed case in Colorado called Balanson, where there's actually been a couple opinions in that, but in that case, kind of the outlier is the fact that the court determined that the vested remainder is a property interest regardless of, one, the contingency of the beneficiary having to survive a current income beneficiary, and two, regardless of the contingency of the current income beneficiary having a power of appointment that could divest the spousal beneficiary, in this case, of their vested remainder. Now, where this really becomes difficult is when you look at spousal irrevocable trusts. And right now there's a lot of movement in the estate planning world where spouses are creating trusts maybe for the benefit of the other, things like SLATs, inter vivos QTIPs, and even NINGs and DINGs like I mentioned. NINGs and DINGs are Nevada incomplete non-grantor trusts or Delaware incomplete non-grantor trusts. And all of these could be created maybe for gift and estate tax planning purposes and or income tax planning purposes for state income tax purposes. But either way, the commonality is that one, they're irrevocable, and two, a spouse has an interest. Now, I give credit to Ed Morrow. He's a wealth strategist with Huntington Bank and a titan in the estate planning world. And he cited on a LinkedIn post a recent Ohio appellate court opinion where the divorce court analyzed a SLAT that had been created back in the 2012 gifting rush and determined that the trust interest created for the spouse was separate property and not marital property, even though it was created from marital property because it was in essence a gift to the spouse. Now, there was one problematic clause in the trust in that case that specifically said that an interest would be a gift and wouldn't be community property or anything, but instead would be treated as separate property. So it's not clear whether that clause was the determining factor or whether the nature of that entire SLAT was the determining factor there. But either way, what I cite that for is the fact that this should put on your radar the fact that it's a little more risky in the divorce context to create this kind of trust. And it's a hard conversation to have in the planning and implementation phase, but a practitioner and a client should consider how spousal interests will be treated at divorce. So if you have a grantor and grantor spouse in the meeting talking about a SLAT, you don't want to really bring this up, but you kind of have to, or you're creating a lot of liability and some potential surprises down the road. Some common top of the bell curve treatments in SLATs that I cite are: one, you could terminate a spouse's interest versus continuing it depending on divorce or even the filing of a petition for the termination of marriage. You could also use, maybe if you're going to terminate a current spouse's interest, you could use a floating spouse provision that keeps the trust as a common trust for the grantor's life, and if the grantor remarries, the new spouse could come in as a beneficiary in addition to the other descendants in issue under the trust. And then finally, you could also consider using language that intends to have the trust be considered by a divorce court in determining property awards and separate maintenance, but without the ability of any interest in the trust being able to go back to the grantor's spouse. So, and I say that as grantor, non-possessive spouse, so really you just don't want the grantor to have any continuing interest that a creditor could seize in this irrevocable trust. So lots of things to keep in mind. But like I said, this is really a top of the bell curve analysis, and it's important to check your own state's laws to know what's going on and what planning pitfalls there might be. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of the 10th of an Hour, and I look forward to seeing you in the next one.